Give me 1 second. There we go. Look, got food all in my beard. Look, got food all in my beard. Let's paint. Let's paint. Do. All right, what up, everybody? Supreme Decisions here, and today, as you see the title, is how not to win in court and the mistakes that sink your case. Now, this is one of the things that I actually brought up because there are a lot of times whenever someone calls or whatever, and I've been working on this case for 3 years, and I don't know what I did wrong. And I get like all kinds of things that come through. Now, what we're going to do is explore the common errors and bad habits that sabotage cases in civil and criminal cases. Because a lot of times this is also things that are carrying over to federal court when you're suing, a government agency or whatnot. Now, for the Supreme Decisions Legal Minute podcast, which this is for, it's the ideals of real courtroom wisdom. And today, we're going to flip the script. Everyone talks about how to win, but today we're going to talk about why you're not winning. All right? So, because sometimes the best way to learn to do something is to understand what not to do. Now, the easy part is I'm going to talk about the most common, and I hate to say it in that kind of term, but it's the one that shows up the most often. And for me, whenever someone calls me and asks for assistance or anything like that, one of the things that stands out is the fact that I know court procedures, which is meaning a lot of times the separation is understanding the procedures. That's why I always speak about knowing the game and understanding the fact that piranha don't eat piranha. So number one is knowing court procedures. Number two, a lot of times what is happening, we'll speak with emotions and we don't take documents that we need, or we don't have evidence because we're speaking on feelings and we think, well, it should be. Well, we don't live in should and know us to cooperate in it. Or we'll forget about certain witnesses at key points. And what I mean by that is not securing witnesses, even if it's for the other side or from the other side, and being properly prepared for that. And here's the thing I speak about often. It's whenever I played basketball, whenever I coached football, one of the things we did, we watched tape. Basically what we were doing, we were researching our opponent. We didn't pay attention to the facts of I hate to use the word jurisdiction, but the jurisdictional boundaries, meaning in Atlanta, there are several subdivisions. There are two that are right next to each other, such as College Park and East Point. Well, the biggest issue is if I'm in College Park in a certain area and someone from East Point stops me and tries to give me a citation or something like that, they are outside their jurisdiction. It's something that I can challenge. There's also something that I can actually bring up and get the case dismissed from. Or we forget the organic code in each state. Sometimes those are things that are so clearly established. Yes, that's one of those things that you'll get that from, because not only Supreme Court cases, but clearly established law comes from organic code, because that means it had to have been there. And since a law enforcement officer is supposed to be enforcing that code, they're supposed to know that. So, and the biggest one I see oftentimes is, again, you get engulfed in emotion and you don't know what exactly the other side is arguing. And what happens is we'll see it, but then we start arguing about something else. Because again, we're living in should and not in reality. Because when we're showing up to court unprepared, it's like walking to a battlefield without your armor. Even if you're right, you're going to lose, because preparation is half of the battle. And then knowing when and where, again, why I speak about chess, understanding how each piece works and how to move them to be successful. So preparation is the price of participation. If you don't pay it, you'll pay it in court. I'm gonna say that again. Preparation is the price for participation. If you don't pay it, you will pay it in court. Oftentimes we have someone speaking for us because we don't know court procedures. We don't know how each piece moves or how it'll work later. So we choose to go about things without the help or without the assistance. And then when it blows up in our face, then we look around and like, we should have gone this direction. But when you have an opportunity for consultation or counseling, you're choosing not to because you don't think you should pay for it. But either you're going to pay now or you're going to pay later. You actually are going to determine the price for it. And what I mean by that, a lot of times it's not monetary. It'll end up being your physical liberty. So it's oftentimes good to at least get the consultation and get the guidance and be willing to pay for it while you're learning. Now, let's talk about letting emotions lead, because again, that's something that I just spoke about, because that happens more often than not, because this is a psychological warfare. This is not about, it's not about just going in and being right. Now, one of the issues that a lot of people have, because I watch it on YouTube constantly, and they'll say, "Oh, that guy, he was doing the thing and he was killing it." You're interrupting the prosecutor and the judge. Even during my RICO trial, one of the things that, my brother's attorney used, because she was like, "Hey, you need to object." And I told her, "No, let them talk." Because the more they speak, the more goes onto the record and the more they have to account for. Because remember, everything you say and do shall be used against you. I actually used everything he said against him and made it for my favor. So understanding, I actually even had a prosecutor come out and read into the record what my charges were. But the problem was he spoke as if he was a first-hand witness. So by doing that, now it becomes hearsay, because he can't be prosecutor and witness. Now that entire opening remark is now stricken from the record. Why? Because I allowed him to talk and I paid attention. I don't want just part of it out. I want all of it out. So sometimes you have to take those gambles, because even when you're doing these things, you have to understand the procedure of doing them. And the biggest one I run into more often than not, someone getting angry, because it does piss you off, because you'll have someone sit there and blatantly lie and it angers you. That's why a surgeon can't work on someone they love, because you have to be emotionally detached. That's why you use the context of someone else speaking on your behalf, or allowing what is done and following the instructions of those that you are having guide you, so you can stay in a calm, relaxed, separated state. Or being sarcastic in court. Now, sarcasm is a double-edged sword. And what I mean by that is you can have sarcasm and it come across as something that's as witty, but you could also have sarcasm that comes across as being assholish. And it is literally a fine line, because you got to remember, the people that you're entertaining with this banter don't want to be there. So it becomes a danger when you're doing that. And you're overreacting to testimony. Why are you, oh, they lied. All of those things the jury is watching, they're paying attention to, and they're holding it against you. Even whenever someone's talking, they're watching facial expressions, they're watching your mannerisms. So even these things can become detrimental, even if you're telling the truth. So these are things, again, about controlling your emotional state, because that's why I also tell people whenever I'm speaking with them or counseling them in their cases, I am offering you expectation management. I'm not your friend. I am the person that you're engaging with and looking for the guidance from, so you can get a specific outcome. It's your choice on what you're going to do with that. And the last, but it's not the least, because that actually should have been number one instead of interrupting the judge, is trying to argue with emotion instead of just stating facts. Because a lot of times you'll hear me speak about this section of it in regards of the devil is in the details, because we're telling every little instance when it's not that time. And most of those details are irrelevant to what you're looking for. And you can be angry or you can be effective, but you can rarely be both. Because you'll hear somebody say, oh, that's possible. Absolutely, it's possible. But getting struck by lightning 9 times is also possible, not likely. So it's stay composed, and judges rule based on law. Because they rule based on feelings, they can then be held liable for those actions. And this is, again, some of the things that I do when I speak about the expectation management. And next, this is one of the habits that I have sometimes, but mostly when I'm in front of this camera. It's talking too much or talking too little. Now, oversharing irrelevant details. That's the emotional part of it that needs to get rid of. Not knowing when to stop talking. I actually had one of those instances where I added on something that I shouldn't have added on in my closing. However, at that time, it didn't affect me. At another time, it possibly did, because it made them deliberate longer than necessary. And refusing to speak when asked direct questions. Now, I love this because I listen to different people on their podcasts. And generally, the reason why I had to scoot up for this, because I want you to understand what I'm saying. It amazes me the amount of adults that cannot answer a direct question. And what I mean by not answering, I mean don't have the ability to. Because I'll ask you a yes or no question, and because we've been trained and programmed to go into defense mode and then explain, you then don't answer. Or, my favorite, the deflection. Why are we deflecting? Just answer the question. Because even I actually had the police officer do that on the stand. He went and spoke about some other stuff, which later I boxed him in on. But then I told him, I said, thank you. I appreciate that. Now, can you answer the question that was asked? Now, again, that's part of the being sarcastic, but it's also holding them to the line for them to stay focused and not take over. But it also made the jury realize that he was trying to evade the question, which is a show of guilt. Listen to what I just said. It showed the jury he was attempting to evade a question simply because I let him talk, not answer, and then restate that same question to him. It showed that he had some level of guilt. These are the things that I also want you to take notice of. Because admitting certain things that you shouldn't in these details, or not answering a direct question leads them to guess. You're dealing with live people. Live people that don't want to be there. And guess what? They don't like you because you're the reason they're there. So when you're doing these things, understanding, being short and concise, don't just ramble on unless you're told to. And yeah, I was speeding, but if it wasn't for that first, well, congratulations, you just admitted that you were speeding. Congratulations, you offered details that nobody needed. Because even in that, when you're asked the question, don't give any more, and just say, always just say just enough. You don't, thank you. No, I don't consent. Now, if you want to get mouthy and a little wordy, due to the advice of counsel, I choose not to answer this or any further questions. Again, well, I was on the, are you a cop? Yes. Are you asking questions? Yes. Due to the advice of counsel and the Fifth Amendment protections, I choose not to answer this or any other questions. But again, that's the long version of no. I do not consent. I actually taught my children that. I do not consent. I do not consent. Sometimes simplicity is the best. Do you mind if I search you? I do not consent. Now, here is the big one that most people just do not like. Failing to respect the process. The biggest one is not dressing appropriately. Now, would I wear this to court? No. Give you an example. Again, if you see the videos, if you go watch my very first videos, you see me walking up in different suits. When I first walked in for my RICO trial, I'm sitting first chair, and I walk in the front because I was the only one that was out on bond. One of the police officers grabbed me. He goes, hey, you guys got to come in through the side. And I smiled. I said, no, dog. I'm one of the defendants. He turns around and he looks at me. He goes, what's your name? So I told him. He says, everyone in the courtroom, excuse me. He got everybody's attention. He looks over at me and said, sir, do you mind turning? So I turn around. He said, for everyone that's in here, this is how you come to court. The greatest part about that was because since I was representing my own interests and I was sitting first chair, they had 3 named defendants on that list. They only saw 2. 1, 2. They only saw 2. Because I looked like everybody else. I understood the mission. I don't want to wear the uniform of a criminal. I don't want to wear the uniform of someone that's not educated. I want to wear the uniform of someone that's supposed to be here. I want to wear the uniform that allows the brain to connect to the words that are coming out of my mouth. Because even on these, one of the things that kind of hindered me, and I actually looked at one of the statements that my brother made to me. He told me you need to change how you dress when you're giving this message because it's not your message. People are turned off because you don't look like your message. I get it. As you see, most times I'm still hard-headed. But again, I also understand where the message is coming from. I'm going to say that one more time. No, I do not look like my message. I'm being hard-headed. But I also understand the platform in which my message is being brought from. Here's another problem that we have: being late. Now, the being late is, I hate to do it this way, but there are reasons that you can be late. One, if you're actually attempting to file paperwork, they'll give you a little grace on that, because there are certain nuances in this, because they're not going to tell you that you have all the power whenever you're going pro se, because you're not using their teammates. But in using it, a lot of times it's being wielded with people who have no idea they have this power. And they're just showing up, just to be showing up late. Now, what happens is you're creating an issue that should not be there in the first beginning, because you got the contract, you knew what time and the arena which your fight was going to take place in. Be prepared to fight. And that's what happens a lot of times. People aren't. So they just do what they want to do, thinking it is okay. Using street vernacular in court. Shorty, bruh, cuz. The amount of time. I'm gonna actually bring up one that kind of gets me. Because I'll go over people's motions that they're writing or getting ready to file or have filed. And there are horrible misspellings. And I'm not talking about, like, you misspelled a court name, or you accidentally had like the wrong city or whatever. It was like something, city, the court venue. You had something that was done, but right, everything else was right. I actually picked up a few, and I don't mean one, I mean a few, where probably it's spelled Prolly. These are adults. Or I speak bout to. Not about, but BOUTTO. Bout to. And the context of this is understanding the court isn't even using our current grammar system. And if you are attempting to do that, you're not even speaking the language of the court. So when the court ignores it, you are making a powerless motion or a powerless request. Therefore, they're allowed to do certain things because you aren't even talking to them properly. You're not even communicating with the court. And then acting like the courtroom is casual, like you going to the club. You're not even going to, even you're going to a business meeting. This is what negotiations are held. It's either you're going to toe the line to your business, because your greatest business is you. Your life, that is your greatest business. Treat it as such. When you go into these business meetings, go in there with a business mind, because they are attempting to shut your business down or cost your business money. So you need to figure out where your negotiating line is and how you're going to hold that line for your business. So we don't treat the courtroom casual, and we also make sure we understand the assignments that are set before you, which is why whenever you come with me, I give you instructions. A lot of times the instructions may seem to be out of the norm, because they're not. I'm not going to tell you, send it here and type in 30,000 address. I'm going to give you direction, because again, it's your business, it's your life, your choice. Because even if you don't file it, or you don't file it when I say file, it's your choice. You're paying me to give you the guidance. You're not paying me to go and be your CEO. You are your own CEO, and you are running your business. So I allow you to do that. I'm an outside consultant, because that's exactly what it is I do. I offer expectation management, and I also show you, if you're trying to win, I show you how to get there. But again, your business, your choice. Because even in the context of this, not challenging the narrative. I'm going to say that one more time. Not challenging the narrative. Letting the officer's statement or even the plaintiff's story go unchallenged, because this is where I talk about challenge everything. Challenge the officer's character. Get the Jiggly information. Talk about the officer's arrest record. Not, not cross-examining witnesses. Not file emotional objections when they are appropriate. Accepting hearsay as fact, because they're not going to do it, nor should you. But again, you need to understand these are the reasons that you're losing. You're just letting them ramble when they shouldn't. You're letting people get on the stand and speak when they shouldn't be. And you're not filing the proper motion or even offering the proper objections when they are necessary and appropriate. And accepting someone's opinion. And here's the great part. I've sat in the courtroom. I watched someone represent their own interests. The prosecution said something that was wildly outlandish. Instead of, oh, that's hearsay, that blah, 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 whatever. The person stood up and went to defending the thing that wasn't even relevant or even a fact. There was no proof of. They went to defending that. Like, wait, what are you doing? Because even, I gave you the example before where I had the young man from Wells Fargo or wherever he was from. He was like, oh, well, we're going to motion to strike because it's language unknown, because he didn't understand what the word res judicata means. I could have defended res judicata. I didn't. I actually used it as a long play to humiliate him. I offer the court a continuance so my opposing counsel, the plaintiff, can find competent counsel. So the plaintiff can find competent counsel. He goes, "What did you just call me stupid?" I said, absolutely. I said, because res judicata is on the first page of definitions in the organic code, and you don't know it. Because why? That offers me the opportunity to show that I even offer, as a defendant, a fair and honest trial with clean hands. Could I have defended that? Oh, well, the res judicata because it's already been decided. No. Still got the same result. Just happened 30 days later. But now he has a lifetime of being incompetent on the record. If anybody goes back to what I talked up here, they did study. They found out who the person that they're arguing against was. They now have ammo against him because he's already been deemed incompetent once. Because even if you don't do something, let the prosecution read things into the record as a witness and not a prosecutor, it becomes fact. Because if you don't challenge the story becomes the truth. And a lot of times what happens, people hear the story, they accept it as truth, and then they defend it or go against it, but not challenge it properly. And every unchallenged lie becomes part of the record. I'm going to say that one more time. Every unchallenged lie becomes part of the record, even if it's a police report, even if it's a, the scene report, officer's notes. All of that becomes part of the record if you leave it unchallenged. Hashtag challenge everything. Now, and here's one I literally had last week. I had a young man I was speaking with, and he was relying too much on common sense. And he goes, well, why not? They should just see it. Believing the judge will just see it is dumb. And I mean that the way I just said that. Believing the jury will just see it is the biggest mistake you can make. Now, here's my rule. Everyone that you come in contact with, all over the planet. 90% of those people are dumb. And I mean it the way I just said that. 90% of the people that you come in contact with are dumb. Now, I want you to understand that there are different levels. The context in which I'm using the word dumb is they are not familiar with a lot of things that are common. Because what's one of the common things we say? Oh, common sense ain't common. So if the common sense isn't common, why would we then expect people to have common sense? If it's rare for somebody to have common sense, why would we then expect everyone to have common sense? That doesn't make any sense. Hence, that's dumb. I want you to understand, believing a judge will just see it, believing the jury will just see it is a horrible mistake. And it should never be assumed. Always be assumed they won't see it, even if it's sitting in front of them. Thinking the law is fair and based on morals. Because here's the thing. I did a podcast regarding the morality of the morality of murder. Did we just have a conversation that murder is immoral, but we're talking about rationalizing murdering? How does that work? So morals can be shifted and shaken and changed. The law isn't fair. The law doesn't care either way. The law is just it. The law is selfish. Stand on law. Because no one follows it. I'm going to say, stand on law. No one follows it. That is why they get upset when you challenge them. They get upset because they know themselves. They have no clue what law is. A police officer, 9 weeks of training. But an attorney, 7 years of school. 9 weeks is what? 2 months? A little more than 2 months, because 1 week you really ain't doing nothing, right? 7 years. 14 semesters. And then you have to take a test. You do 14 semesters of learning, and then you have to take a test. But he's supposed to know law and be able to enforce it in 9 weeks, which is 2 months. Yeah, law isn't fair because we don't understand the context and the concepts. We don't understand how each player is moving. And here's another one. Not understanding the burden of proof. Sometimes we're talking too much. Because every time you open your mouth, you have to prove something. Not understanding what facts are. Because the law isn't logic. It's structure. And the biggest thing is most people try to confuse and conflate the ideals when in fact the law doesn't care. The law just is. And point number 7. And again, one of the worst things, not responding to filings. I always tell people, whenever you're doing anything, the biggest thing is the answer. Answer everything. Answer everything with something. But the problem is, you have to know the procedures. So you have to know what you're answering and why you're answering. So you have to know how to answer it. That's why you get someone who knows the procedures. That's why you pay for it now, so you don't have to pay for it with your liberty later. Next part, missing deadlines. Now, certain motions with certain actions have certain deadlines. Now, here's the great part about that. Even in that construct, is understanding when, why, and how. Make sure that everything is on point. And generally, because let's say you have a deadline that's 10 days. You might want to do it on day 1, depending on your strategy. You might want to do it on day 9, depending on your strategy, but you want to do it before day 11. So it's depending on what you're doing and how you're doing it is how you'll not miss these deadlines, but understand when they occur. Ignoring discovery. Now, I've shown this, I've talked in nauseam about this. Very few people know what a detailed discovery is. And those that do generally start out at $50,000. Why? Because it's $500 an hour for 100 hours, because each case requires 100 hours of knowledge. So they're charging you $500 an hour, which is $50,000. So if you're not paying someone $50,000, you are not, if you're getting an attorney, you are not getting a top tier attorney. You're probably going to get someone that doesn't know what discovery is or a detailed discovery is. And they will write something that says discovery that's vague as hell. Why? Because they're allowing the prosecution not to turn over certain evidence, which allows them to then skirt past what it is that you're trying to do, which does not allow you to structure a proper defense. Ignoring discovery, not knowing what's in there, because even whenever you're dealing with me, one of the things I always talk about is not only what's in discovery that they give you, it's what's not there. What are they not turning over? But if you don't know what's supposed to be in there or what you need to ask for, you're ignoring discovery. And I've actually had people, oh, well, yeah, they turned it over. They turned over everything. And I'll ask them, did they give you everything on that list I handed you? And then all of them, no. Okay, but you just argued with me for 10 minutes saying they sent you everything. And now you're wondering why you got the result, because you just accepted it and ignored discovery. And not reading court notices. When you not read court notices, again, you don't know what your opponent just moved, what space they just moved into. You can lose by default, and many people do, simply because they don't understand the response. Now, how do you flip these mistakes? One, you shoot me an email. Then we set up a time to sit down and have a consult. And then you shoot over the Cash App, to Zelle or Apple Pay. And we start working. And you send me all documents that you have. Because I'm not going to allow you to miss any deadlines. I'm not going to have you do things, as long as you get them to me, that we can't respond to. I'm not going to have you do all the things that are going to be in this list. Because I'm going to show you how to prepare. I'm going to lead you with calm within the chaos, because that's how this system is designed. It's designed to be chaotic. The devil is in the details. Always understand that. I'm even going to teach you strategies on how to remain calm. We're going to have conversations. We're going to speak strategically. You're also going to be set up to where you can act strategically. I'm going to show you the process so that way you can offer it respect. We're going to challenge everything. Everything that you allow me to show you how to challenge, I'm going to challenge it, because we're going to change the narrative. We're going to challenge what they're saying about you. And we're going to advocate for law, not feelings. I'm going to say that one more time. We're going to advocate for law, not feelings, because I'm going to give you things that you probably didn't even think of, even when we're setting up these motions. Because a lot of times I'll read someone's motion, or they'll have a motion prepared. They'll then pay me for a motion. I'll send it to them. And then they'll be like, oh my God, you used a bunch of cases that I'd never even thought of. I was like, because I haven't been doing this a week. I've been doing this damn near 20 years. I haven't just started. This is what I do. I live this. And make sure your paperwork is done properly. And what I mean by that is knowing what does what, when, where, why, and how. That's, again, one of the mindsets in which you need to kind of inherit. Because court is not about justice, not about law. It's about rules, timing, and evidence. So court is not about law. So if you're walking in court, civil, criminal, or otherwise, don't sabotage your own case. What you don't do may be just as important as what you do. So, like this episode, subscribe, write a review. Give me one of your stories of how you've had these matters in which you possibly sabotaged your own case. And share it with someone who might need courtroom wisdom before they make court mistakes. Supreme, and I'm out, people.